Welcome to This Week's Okay at Work with myself, Sarah Sawyer, my colleague, Russell Berger, both attorneys at Offit Kurman. And today we are talking about another executive order. We've been talking about these a little bit as they come out, but another one has come out, and this one relates to the disparate impact theory and the EEOC. So a order essentially telling the EEOC not to pursue or investigate claims for disparate impact. So what is disparate impact, Russell, and what does this mean?
Yeah, obviously, we talk about discrimination claims and harassment claims a lot. And what disparate impact is a theory of liability under that discrimination umbrella that basically says if you have a facially neutral policy, so something that is not inherently discriminatory if you just read the policy, but that it has a substantial enough from a statistical standpoint impact on one protected class relative to others, that it can constitute discrimination under the law. So, as an example, if you had a promotion policy that was based on meeting certain criterias, but when you looked at the data, like only men get promoted and women never get promoted, even though the data is objective, that could lead to a disparate impact claim. And so what the executive order says is it's the White House directing the EEOC when they take actions, because sometimes when you file a discrimination claim, you get a right to sue and the individual can pursue their claims on their own. And sometimes the EEOC will take over a claim and pursue it. But what this executive order basically says is it directs the EEOC to not pursue disparate impact claims as a party. It doesn't wipe out the law. Title VII, which is the federal law on discrimination, still exists. Disparate impact still exists. It's still recognized by the courts. An executive order can't wipe that out. But the EEOC isn't going to pursue any disparate impact cases under this executive order.
And I think that is always a confusion sometimes because a lot of people are very familiar with the EEOC and how they function and see them as the law. But really, they're an enforcement agency. And ultimately, the courts are going to make the interpretation and decisions around Title VII. And that still exists and that's still established in good case law, despite this executive order. There's also state laws as well that come into play here. So a lot of states have specific laws or rules around this. So that's something to keep in mind as well. As far as what's changed, the enforcement's changed, but the law is still there. You really still need to be mindful of these things. And it can be a little bit confusing, I think, when you see a headline that says impact theory is out. It's all gone. Not really. It's still around, still alive and well. It's just going to be a little bit different on how plaintiffs or employees are pursuing it and what their avenues are.
Yeah, the charges that get filed with the EEOC may act and pursue, I don't know, 1 to 5% of those. And otherwise, they go through the process, they investigate, and they issue a right to sue letter at the end. And the individual claimant can bring that in court or not. So it's rare to begin with that the EEOC is the party and is involved in driving a claim forward in that way. While this is headline worthy, it really doesn't change anything from an employer perspective. Like you said, Sarah, it's still on the radar. It's still something you have to be conscious of. It still should be a factor in how you make decisions and set up policies and review them. So it shouldn't really change any of that. And even if it did, there's still state level laws that say ostensibly the same thing. The advice here is be aware of the headline. It's noteworthy, but it's not going to change, and it shouldn't change the day-to-day practices of an employer.
Yeah, it's more of an indication of where the mindset of the administration than anything else.
Sometimes it's not so much always we're not going to pursue this. It's usually we're going to emphasize this other point, but it's a finite amount of resources in the EEOC to pursue these claims. So there's always preferences and swings. And this is just a more curt version of that than I think we're used to seeing.
Yeah, I think that's a good way of putting it. Thanks, Russell. We'll see you next time.
Thanks, Sarah.